Trial and a couple of motions that were filed. We have the names of our participants, please. Who's our guardian ad litem? Hang on, Mr.
Here as the guardian ad litem.
Thank you. Ms. Sasha Thomas, counsel for the department.
Attorney Your Honor, William Amadeo, P7619, for also counsel for the department. To my left is my worker. State your name.
Chelsea Grant with the department.
Good afternoon, Your Honor. Alex Lizahu on behalf of the respondent who sits to my right.
And your name?
Matthew Higgins.
Thank you. Very good. All right. Any preference on which issues we're taking first, gentlemen?
Your Honor, could I suggest that we get the two motions out of the way since they've been addressed by effective counsel today? Put that on the record. Is that fair?
Any objections?
No, not at all, Your Honor. And is non-responsive mother Leanne Higgins present on Zoom or not?
She is. While she's logged in, could you confirm that you're here, Ms. Higgins?
I am here.
Thank you.
I think that's everybody just for housekeeping. Do you want me to make a record?
Yeah, I'll correct you if you're not.
So based on the two motions, Your Honor, we have no objection to the discovery. Obviously, you would be the gatekeeper for what's admissible. But if Mr. Liza wants to dig up whatever discovery he feels is relevant, there's nothing in the department's possession that's not been provided to him other than the CAC interview, which we're going to do under protective order. I'll discuss protective order briefly, but I have no objection to his motion. If he feels something is relevant, obviously I would need to review it and you'd have to determine if it comes in the trial, but I have no issue with his discovery motion. I just don't have possession of the things he's requesting.
Okay. Your position, Ms. Berger, on the discovery motion?
I take the same position as Mr. Amadeo, Your Honor.
Okay, does that help you resolve that one, Mr. Lizahu?
It does, Judge. I didn't want an issue of interpretation coming in here arguing about something. I wanted my third-party discovery. I did already make my request for a discovery from opposing counsel, but as I indicated in my pleadings, there were other things I needed. So yes, if Mr. Amadeo has given me everything, how can I ask for more? But there are other parties I might be interested in getting discovery from.
All right, I'll look for an order on that whenever you're ready to provide it, either under the 7-day or by stipulation once that's directed.
Thank you, Your Honor.
As for the second motion, Judge, it is my understanding, Mr. Lizahu, please correct me if I'm wrong, that you want an expert to view the CAC interview?
Well, so the order as written and signed by Your Honor prohibits me from even showing it to my client. And I don't know that that was the intent. I don't think it was, but I'm not going to play games with your order. I'm going to do exactly as Your Honor says. So I'm looking for several things. Number one, to be able to share it with my client, which opposing counsel is okay with that. Number two, they've indicated no issue about me having the CAC interview transcribed. That's great. We're all on the same page. And I've agreed that to the extent I'm going to be using an expert on the CAC interview issue, I will share my expert's curriculum vitae with brother and sister counsel so that they can see that it's a qualified person to be able to testify on the issue. And they likewise have agreed to provide me with a curriculum vitae of whomever performed the CAC interview. And I'll have one other point, two other points, Judge. First off, I've asked brother counsel, is there more than one person that you're going to be using to establish any evidence regarding the CAC interview? He's indicated to me no. So that I'm not worried about any other CV than the one he's going to give me. And the other point I needed to make, Judge, I have not received the CAC interview until a few moments ago. So I have not seen it. I haven't reviewed it. I know nothing of it, but I want to represent to this court that I have not had it before today.
I'll respond to that when appropriate, Judge.
Have we had the order released?
The order, we just got it. When did we get it? Today?
Your Honor, if I may, you had signed this order in September 1, and given that it was prior to Lenawee Advocacy Center changing to their electronic form of sharing these video recorded statements. We had to wait for the thumb drive to be produced. And so I got that at the end of September. And just today, I have provided that to Mr. Lizahope. As it relates to the language in the order, there's a specific citation to the statute, MCL 712A.17D, subsection 7, which specifically states who's entitled to review that video recorded statement. And that language is not entirely reflected into the order. And I believe that was the point of confusion for Mr. Lizahope, but because of that citation, I believe it's encompassed in there. And we have no objection to his client reviewing that.
And I guess the only other thing, Judge, certainly his client can view it. The big issue of his motion is this expert. I don't know who the expert is. And quite frankly, Your Honor, you're the gatekeeper here, not me. So no matter who his expert is, I can't just stipulate to that. If Mr. Lizahope wants an expert to study this CAC and come in and testify, we need to have a Dolbert hearing for you to determine if that expert is actually qualified. I have no objection to a Dolbert hearing, but I cannot stipulate in good faith to his expert. Well, number one, I don't know who the expert is. Number two, I'm probably not qualified to determine what their CV is. And three, the court will say you're the judge of this. You determine if an expert is admissible or not. There's no way I could stipulate to that other than to say I think we need a Dolbert hearing to determine the credibility of his expert.
Would that be before this person is able to look at the CAC interview?
That's a concern Mr. Lizahope has. And I think it would be before, because if they are an expert in this field from past experience, they can be an expert without viewing this. I think it's the determination of the court, is this person even able to be an expert based upon what their CV may say for them to study it? I don't think they can study it before being determined an expert. I can't think they use the CAC as a tutorial to determine if they should become an expert. Either an expert or not. They either possess those qualities or they don't. Once this court determines they're an expert, if that happens, then they could view whatever they want if that's acceptable. But I don't think they should be able to study and say, okay, I'm an expert because I see certain attributes. They either got to have those attributes or not prior to the study of the CAC.
Mr. Lizahope, that would seem reasonable to me, given that the statute does keep close to the vest on the number of people who are entitled to view that CAC, and that would honor, it seems to me, the spirit of that particular language in the statute. What are your thoughts?
My thoughts, Judge, of course, I'm going to share the CV with brother counsel, and I'm not going to waste my time finding somebody to be an expert unless they're qualified. And I'll look at it and I'll study it. And if there's an issue, we'll bring it before Your Honor. But yeah, I don't have any issue showing the CV of the expert to brother counsel before viewing of the CAC interview. It's a very simple process. I got the CV, I send it to him. Now if he calls me and says, Alex, you know, your expert it was educated in Indiana instead of Michigan, so I opposed the use of this person as an expert. Well, then we come back before Your Honor, and Your Honor will decide that. I don't have an issue whatsoever.
Well, I think what he's saying is that I would need to give you essentially permission to allow this person to review the CAC and do that analysis first.
Well, I thought the permission was from brother counsel, but if Your Honor wants us to present the CV to Your Honor first, I don't have an issue with that either.
Thank you.
I wouldn't want somebody that's not qualified to do it, of course.
And I guess, Your Honor, the only point I'm making is you'll determine our qualification, not me.
Yes, get to, have to. Is Berger, any thoughts that you'd like to share on this conversation?
I have nothing to add, Your Honor.
All right, so to me, that sounds like we may need to build that into the schedule moving forward. Do you have any idea who you're going to want to use as your second evaluator?
I do, but I wanted to speak to the person first.
Okay, all right. Well, part of what we're addressing today for purposes of pretrial is, of course, the timeline that we have set for trial. Is this going to impact our current dates that we have set?
I believe it might, Your Honor. Moreover, I've been working up my file, and I believe I'm going to have more witnesses than I originally anticipated. And I don't know that 3 days would be enough, so.
As of right now, yes, I have the 3 days in January.
Wait, I'm sorry. You don't think 3 days will be enough for this trial?
No, I don't.
I've tried capital cases in 3 days with 12 jury picks. I really find hardly we won't get this done in 3 days, but I'll defer to brother counsel. Can you give me an idea how many witnesses you think you're gonna have? That would take more than 3 days?
Actually, I have a list, I'd have to pull it, I have like 8 people on the list.
Can I just ask, how long do you think this trial will go? If you had the
I don't know,
ballpark.
4 or 5 days.
You will find that I do challenge on whether or not we're going to be hearing the same sorts of testimony more than once. So I would just encourage you to keep that in mind, that if you have 3 different witnesses that are going to be testifying to essentially the same facts or circumstances or similar ones, then you may have me challenging you on that point, as well as I'm sure your fellow counsel. So I don't know who your witnesses are or what they intend to do, but you may want to consider consulting with your fellow counsel prior to, in order to make sure that you don't have that issue confronting you during the trial.
Not interested in duplicativeness whatsoever. But to the extent a particular witness can offer evidence that I believe is material to the case, I do intend to introduce that witness.
I guess, Your Honor, just to respect your court judicial economy, I may be asking for offers of proof before we determine how many witnesses, because respectfully, it sounds like brother counsel has a ton of witnesses they intend to put on. And my concern is if it's cumulative evidence, I'm going to challenge everything. I don't know. But this is the first I've heard it. We're going to need 4 or 5 days for this type of trial. And again, I'm trying to bring my experience in. I've done murder cases in 4 days. So I find it really excessive that we would need 5 days for this trial. But if that's the case, I would request offers of proof if it's going to be witnesses that have nothing to do with the discovery.
That's also something that I would want to have settled before we bring the trial or the jury in. I also don't want to commit, our community members for more days than we need to, or waste their time as if there's an argument or a battle about what witnesses are going to be there. So I simply suggest we build that into our final pretrial and look through that witness list and have that ready to go. If there's a disagreement on which witnesses are going to be called in front of the jury in our final pretrial, that sounds like it's something that we can accomplish.
I have no issue with that, Judge.
Mr. Lizigu?
Yeah, we can do a witness disclosure. That's fine. I'd be more than happy to. And as discovery moves forward, I might have additional witnesses, but I don't mind a preliminary witness list. I think that'd be fair. I think it'd be fair to me too, because then I know who they were planning to bring.
So I guess the last issue is your client has a right to trial within 6 months. It would be quicker than that, but at the latest, it would be 6 months. And if we go out past February 11th, or around that date and time, then that's going to be beyond your statutory right to a speedy trial. Is that going to be an issue?
I'd have to consult with my client, Judge. I do have my calendar with me. I have open dates in January as well. So I'm willing to work with the court, but I'd have to consult with my client on that.
All right, well, respectfully, Your Honor, if we're going to do a Goldberg hearing, we're asking for 5 days of trial. I would certainly hope brother counsel would waive the speedy trial aspect of things. If not, we're going to be really getting slammed with things that we just found out about today. So I would encourage, obviously you're a boss, for him to speak to his client now to see if we're going to waive that, because we're not going to waive that. That certainly changes a few things on our end.
Well, I'll consider it with my client, Your Honor, but I'd like to have 30 days before I make that decision.
That's not going to be possible. When I look at my calendar, Mr. Lizigu, because if I move your trial that's currently scheduled for January 8th, 9th, and 10th, you, for 5 days, you are looking at, frankly, even if I give you a backup to a previously scheduled delinquency jury trial, the earliest I can possibly give you is March 4th through the 8th.
May I speak to my client for a few minutes, Your Honor?
Mr. Lizzio.
Yes, Your Honor, thank you for the opportunity for me to discuss the matter with my client. We will waive the 6-month requirement. I understand that it won't be past the January trial date.
All right, as a secondary piece of that, Ms. Berger, do you think that that's in the children's best interest, understanding that at that point, we will have waited quite a bit of time in order to have a resolution on this issue?
I think it depends, Judge, on the recommendations from the counselor, honestly, which I don't know if we have those back yet or not, but it seems like a long time to put that amount of stress on a young girl.
Now, we don't have anything on that particular issue. I do have the recommendations from Ms. Moore as it relates to contact with Mr. Higgins. Do you have anything that would relate to any further delay as a result of the motion? So let me table that for a few minutes and consider what I have in front of me in addition to that, as well as any other arguments on the point. It for issues that we have to discuss for purposes of the trial?
I guess the only other housekeeping issues would be, and I know it's not admissible at trial, but I did say to Mr. Liza, if his client wanted to take a private polygraph and present it to me, and he passed, that would go a long way for me. But I don't think they have any interest in that. And I guess the last thing for housekeeping would be, and I'm only saying this with no disrespect to you, sir, but with the amount of witnesses that allegedly, or at least what I'm leading to believe could happen, if this is going to be a bashing of Leanne Higgins on her character, she's not the one on trial here. So I would stress your honor, I would want to offer a proof there's going to be an extensive witness list. Because I think this case is pretty clear. If we're going to have a 5-day trial, if Leanne Higgins is going to be the one that's going to be on trial, I'm going to take a personal issue with that. I think we need to talk about the relevancy of the case. And I am concerned with the lengthy amount of alleged witnesses that could be coming. I've never had a case your court that would take 5 days. So that's a little concerning. And I don't know what rubber counsel's strategy is, but if that's the situation, I really think we need to have an offer of proof long before these trial dates are in place.
Well, I'm looking at my schedule again. I can give you some time, actually, the first full week of February, if everybody's available. Or I can give you the last full week of January, if that helps. And that stays within the time frame. It also gives you a little bit of extra time.
Oh, could we do the first full week in February, Your Honor?
Are you available, Mr. Amadeo? And again, I will schedule the 5 days, but then we're gonna have a pretrial where we're gonna look at whether or not that's gonna realistically need to happen based on the witnesses. So I would ask you to provide a witness list with at least a brief statement on what each witness is intended to be used for by way of offer proof. And if you want to circulate that to counsel before you bring it to the pretrial, that's fine with me. I don't need to look at it if you have an agreement. If you know they're all going to be people that you're going to call, then it doesn't matter to me. But if I need to make the decision on whether or not a particular witness is going to be called, obviously I would need to be prepared to do that.
With all due respect, Judge, if I'm required to do an offer of proof, I'd expect brother counsel contemporaneously to provide a witness list and likewise with offers of proof.
How many witnesses do you intend to call, Mr. Amadeo?
Your Honor, if I may speak on this point, the witness list was filed today with this court and will be circulated to the parties. There's the CAC interviewer,
Okay.
law enforcement officer in charge, the complaining witness, I guess all 4 children, possibly Liam Higgins, and then obviously the respondent father.
About 7, Judge.
Okay.
And as far as the trial docket, the 5th to the 9th, will we start at 9 a.m.?
Yes.
All right. The short answer is that will not work for me, but I'm going to start moving things around because I don't want to hold this up any longer. Basically, I'm in trial docket chaos, but if we have enough time, I can start making calls now to clear that week if that's what we need to do.
Okay. Well, I appreciate that. Ms. Berger, does that work for you?
I have one pretrial in Jackson County via Zoom on that Thursday morning, but it's at 9 a.m. So if we need that day, I could step out. We could take a brief recess, maybe start at 9:30. If that would be okay with the court. Otherwise, I am free the entire week, which never happens.
I was starting at 9:30.
I'm out, Your Honor. I'm sorry. One day I won't be the problem.
We can send, of course, any accommodation necessary for any attorney in this matter. Of course, we would consent to that. And I do want to add one other thing, Your Honor. I respect that sister counsel said they filed a witnesses. I haven't seen it yet. But again, your order is for an offer of proof. So to the extent they need to amend their list or indicate what the offer of proof is, I'm going to ask that that be done.
I would assume that the CAC representative would be testifying to what's within the CAC interview. That the law enforcement officer would be testifying as it relates to any report. Does that be right, Mr. Amadeo or Ms.?
That'd be correct, Your Honor.
Okay. The complaining witness testimony, I would think, would be contained within the complaint, as well as anything that the children would be saying would be either in the complaint or in the CAC interview, as well as the statements by both parents. Is that safe to say?
That is safe, Your Honor.
All right. So I think the reason, Mr. Lizahoop, we're asking you to tell us who you would be calling is that I can clearly see the relevance of all of these witnesses. And I would just ask you to let us know what your witnesses will be contributing.
I can, Judge, just that if they could put it in writing too, so it's something that's documented, I'd appreciate it. But yeah, I can do that. That's not a problem.
Do you know who your witnesses are going to be at this time?
Mostly, but not all.
So if you would like to go through them at this point, similarly to what your fellow counsel has just done, I would be willing to look at that same issue just as I just did for Mr. Amadeo and Ms. Thomas.
I don't have that material with me today, Your Honor.
All right, well then I will ask you to do that in the future with them, and I'm not going to ask them to put in writing what we just established on the record.
Thank you.
Okay. Ms. Berger, are you gonna have any witnesses?
I can't imagine I'll have anyone other than the petitioner's witness list and respondent fathers. No.
Thank you. So let's talk about final pretrial and any motions in limine.
I will have some, Your Honor. I know that.
I think, as far as motions and limiting, Judge, that's going to depend on the witness list I receive. I imagine I may be filing some, but I can't actually speak intelligently on that until I get the witness list.
Mr. Lizahoop, what do you anticipate to be your discovery process? Will it be interviews, deposition? What do you?
Well, to the extent that the people are voluntarily, I can interview them, I will. I know I'm going to do at least one deposition, possibly two. And there's some material that I'll be getting from a certain court. I'm going to have to get certified copies of documents of that. I think I might be able, using some of the witnesses that are related to those juvenile proceedings in the Wayne County Circuit Court.
And I'm sorry, Your Honor, did I just hear correctly that you're going to do two depositions at least?
Yeah, at least.
Okay. Do you know who you're going to depose?
I believe Ms. Higgins, Leanne Higgins, and I also identified in my motion Tad, T-A-D, Bailey, B-A-I-L-E-Y.
And so, Your Honor, I'm sorry it's taking up so much time. I'm not sure what Tad Bailey has to do with this case. I'm not sure it's appropriate to depose a non-respondent mother. I mean, court will say we can make her available for him, but an actual deposition? What are we doing here? I'm a little confused.
Your Honor, can I say something, please? Discovery preserves testimony, narrows issues. To any degree, that would be actually instrumental to the trial of this matter.
A deposition of the non-respondent mother would be instrumental. Respectfully, it sounds like we're on counsel in a fishing expedition to put Leanne Higgins on trial, which was my concern with his excessive witness list.
Well, I don't consider my witness list I haven't filed yet as excessive, and we do believe that Ms. Higgins has been unduly influencing the minor child.
Okay, well, respectfully, that's a fair thing that you could bring up on cross-examination that our judge could determine if it's relevant or not. Secondly, your witness list, you requested 5 days of a jury trial. So I'm assuming it's going to be an extensive witness list. And one of my concerns that I made very clear in court was that I don't want Ms. Higgins on trial. So if we're putting in a bunch of witnesses to attack her and depose her, I'm really confused what the relevancy is on that.
My client does have the right to present evidence at the trial. We believe Ms. Higgins has been unduly influencing the child. I documented that in my motion.
Yes, I did read your motion.
21 CPS involvements, physical abuse, threatening the children, giving them medication to make them sleep that's not prescribed to them.
Okay, so I have a client.
Neglect, failure to protect. Ms. Higgins has a pattern of false accusations.
Ms. Higgins is not the one who's accused of molesting her child.
Ms. Higgins is
not the one who's
probably
accused
the
of
one that made the
apology.
child say that to get back at my client.
Do you have any?
All right, so just in case you're curious, the court rule that governs whether or not you can have a deposition is 3.922 subsection C, AC. Depositions may only be taken as authorized by the court. So I think I would need to have the relevance and obviously balance that against some of the concerns that Mr. Amadeo is illustrating as well. There are a number of things that are to be automatically disclosed, which are indicated in the same rule. And as far as I understand, this is all happening already.
Well, they haven't given me everything. They've given me some of the materials. They did comment to me that they're not obligated to do that until 21 days before trial. So I'm expecting more materials, but I'm confident I don't have everything.
Your Honor, that's a gross misrepresentation of what was reported to him. Stated that as we obtain materials that need to be given over discovery, we will do so. And noting that we still haven't or whatever is irrelevant to us because we have until 21 days before trial to do so. And that's how that was framed in our conversation. So I just want to be clear that we have, as of today, handed over everything that we have.
Okay, I'll just put that in the order. They'll provide materials as received. That's not a problem.
Yeah, what actually sister counsel told Mr. Lizahope is that the court rule says 21 days before trial. We would get him the material as soon as possible. If there was any other material. Nobody was holding anything back.
All right, so for purposes of pretrial motion and any motions of limine, I would offer you the afternoon of Tuesday, December 19th.
That's fine. December 19th, when you say the afternoon, did you want a certain time, like at 2:30?
1:30 p.m.
Not available.
Not available? Are you out particular days that I could take note of?
I'm technically out the 14th through the 3rd, but I will otherwise make myself available for this court, but I am not available at all on the 19th.
Your Honor, if I may, is there a possibility we could use the currently scheduled trial dates in some form as the pretrial?
My concern is the pretrial dates, using those in lieu of what we had previously scheduled doesn't give me a lot of time to reclaim the days that wouldn't necessarily be used.
Understood, Your Honor.
And if there's anything else that comes up in the meantime, I'd rather know sooner than later.
I'm fairly open the rest of that week, Judge.
Well, if we go out and after Ms. Berger is back, I have the afternoon at 2. I have 2 hours on Thursday, January 11th. I can. When then do we need to have the exchange of witness lists? Obviously, the department's filed theirs today. Mr. Lizahoop, when do you anticipate yours being ready?
I can do a preliminary witness list within a week, but again, I'd be adding to it as the case progresses. So I can do as Your Honor orders.
All right, preliminary witness list then by the end of the week, and your final witness list by November 30th. gives you about a month, just a little bit more than a month for your discovery.
So as far as depositions, Your Honor,
You'll have to ask me formally when you decide who you want to depose and file a motion on it.
thank you.
I would suggest that's all filed and finished and completed by the time the pretrial is done. Because if you come to me and ask me to depose someone at or after the pretrial, the answer is going to be no.
On November 11th, 2024.
That's definitely too late.
Oh, I didn't, maybe I misunderstood,
So-
Your Honor. When was the final pretrial?
So-
Was November, excuse me, January 11th,
Thank you.
2024,
Yes.
right? I misspoke, I'm sorry.
That's okay. That's the final pretrial, yes. So if you want to depose someone, if your witness list is due November 30th, that's also, I'm gonna just say that that's the last date that I'll accept a motion for a deposition. I would like you to make that,
On November 30th, Your Honor?
yes,
Okay, last day to accept motion?
that will be, you'll need to schedule it to be heard at or before that date. Well, I guess if your final witness list is due, you can have after that.
Thank you, Your Honor.
So filed by November 30th. Any motion for deposition has to be filed by November 30th.
Thank you, Your Honor. Your Honor, can I ask one other thing, please? Is the court going to prepare the order? Do you want counsel to prepare your order?
I'm going to be preparing the pretrial order, which will have some of the contents of what we're discussing here today about the motion cutoff dates, the scheduling. On your motions, I would expect you to prepare the orders.
Thank you very much, Your Honor.
All right, so from where I'm sitting, I have that it's necessary to adjourn the trial. I've done my best to adjourn that to a week where we can try to continue forward in a way that honors the fact that we need an answer here within statutory timeframe. So we're looking at the week of February 5th through the 9th. We have, of course, the preliminary witness list due from Mr. Lozano by the end of this week. The final witness list with the motions due by November 30th for depositions. Any motions in limine, I'm happy to hear at our final pretrial date in January. We've used January 11th at 2:30 for that. So obviously you'll have to have those filed and served in order to have those heard on the afternoon of January 11th. There were a few things that were ordered at the last juncture. Mr. Amadeo or Ms. Thomas, whoever would like to speak to this. Obviously, we have a recommendation from Ms. Renee Moore on contact. And some updates, I'm sure, on some of the issues that were raised last time.
Did we want to take testimony for review, Judge, to clear that up? Do you just want to provide some content?
Mr. Lizahood, what would you prefer?
I don't know what they're gonna say, so I am under the impression that Your Honor ordered certain counseling. I don't know what the status of that counseling is. My client did participate in that, and I think there's been some delay in that, so I would like to likewise know what's going on with. I think that children are the most important part of any case, and to the extent they need the counseling, I'd like to know what's going on. I don't know.
Did you receive a copy of the court report prepared in anticipation of today's pretrial?
I have today received investigative report.
Mr. Zahobi, it would have been provided to you via email this week before today's hearing.
I think I did receive something last week.
All right, because typically what I would anticipate happening is that the caseworker would testify and be available for questions on the information that was provided ahead of time. So if you have questions for our representative, I'm happy to go through the full pretrial review, but if you'd like to avoid that, considering the circumstances and the allegations in the complaint, I would be willing to entertain a motion to simply receive these updates and issue any orders moving forward that would be necessary to make sure that the children's needs are being taken care of.
I'd make said motion on the part of the department just to amend all the court reports and the update, and as you stated, Your Honor, I don't think we need to do a full review today. I'll defer to yourself and brother counsel on that.
And this is limited just to, for purposes of free trial, it would not be admissible or usable during any trial, Mr. Lizzie, just so you're.
Well, to the extent it's not usable at trial, then we will not insist on having the testimony of the caseworker. And we'll allow the court to review the report directly and make its decision.
Thank you. Ms. Berger, do you find that to be in the interest of the children in this case?
I do, Judge. I would just like to give a report at the end.
Yes, and I would look forward to your recommendations on, for example, counseling and any contact between the children, given the materials that we received today. So whenever you're ready.
Oh, thank you, Judge. I was able to visit with the children in person during this reporting period. I was able to speak with them individually in their respective rooms. I was also able to speak with them kind of generally together with mom and without mom. I was also able to speak with mom individually as well. I was able to view the home. It's appropriate, it's clean, it's tidy. Maybe plain would be a good way to explain their rooms, but it was kind of a last minute situation to where they were put with mom full time. So I know that they are working on those things, but they have plenty of clothes, plenty of activities, phones, tablets, games, all of those sort of things. None of the children want contact with father at this point. None of them have heard from him. None of them want to hear from him. I know that we do have a recommendation from Ms. Moore that parenting time continue to be suspended and that contact slowly begin with letters from father. I would ask that those letters go through someone at the department or at least the counselor so they can review those and make sure that they're appropriate before the children get put their eyes on them. There was inappropriate contact by father with the oldest child during this reporting period. And that is a bit of a concern for me. I would just like to make sure that the parties are aware that that is not supposed to be happening while this court's order is for parenting time to be suspended. Otherwise, they seem to be adjusting okay. I know that the other children in the home support the minor daughter in this case and her accusations. They're aware of them and they're in support of their sibling. So at this time, Judge, I'm asking that parenting time continue to be suspended, that any contact be via letter form and reviewed by the caseworker or the counselor, and that the children continue with individual counseling.
Your Honor, can I respond, please?
Yeah, well, I was gonna go to DHHS first and then give you an opportunity. I would imagine you'd want to hear what they have to say as well.
I would, Your Honor, but to keep it consistent with what she said and I could respond, I think it would be easier to follow. My only comment, Your Honor, is she's alleged that my client's made an inappropriate contact with the oldest child. That I am aware of what she's talking about. That was done before any court order precluding any contact with them. So we refute and dispute as untrue that there was any inappropriate contact by my client with the oldest minor child.
Thank you. Mr. Amadeo?
I would concur with what Ms. Berger said. She's actually on the ground on this issue. And I'll turn to Chelsea Grant. If you have any issue with what Ms. Berger recommended.
Yeah.
The fact that Ms. Berger and Ms. Grant do know this issue more than anybody, I would stick with their recommendations there, Judge. As far as the inappropriate contact, if there was no court order in place, I'm not making a contempt issue or asking for any penalty there, but I would trust anything that Ariel Berger has to say. Thank you.
Well, I don't see that there was even really any mention of that, and I'm not hearing that it was a concern. I think it was more just a signal, Mr. Lizahoub, that we want to make sure that we're following the recommendations of the counselor in the court at this time. Do you have any objection to the recommendations of the guardian ad litem moving forward?
Not at this time, Your Honor.
All right. Anything in closing or anything else I can address today, Mr. Amadeo?
I think you've heard enough from us. Thank you, Judge.
Your Your Honor, I do need to bring something up to the court. I brought it in my pleadings. I want to address it to the court. Ms. Higgins is taking this girl, 12 years old.
Okay, let's not go ahead and report names on the record for purposes of today's hearing because we are on YouTube. And due to the content that's in the petition, and out of respect for the child, I'd like you to please just use initials.
I apologize, Your Honor.
Sorry.
I think it's,
I imagine it would be MH. And I understand
MLH, Your Honor. Okay, Ms. Higgins is taking this child and she's coaching the child, having the child repeat these allegations and correcting supposedly these allegations to numerous parties. We have at least one party that she's had done that to. I attached the text in my motion regarding that. I'm concerned that she's unduly influencing the children and having them repeat this to relatives and things like that. She's already poisoned the well with respect to all of my clients' relatives. And she's spreading this around, and I don't think that's in the best interest of the children or in the best interest of the community at large, including my client. So to the extent she's haranguing the child, interviewing the child, making the child repeat the things, repeat them to other persons, I think that's improper.
I'm almost scared to say this out loud, but I only think the way this court could determine if these allegations are true would be to have an evidentiary hearing, not hearsay and text messages with absolutely zero context. Again, I hate to say this, Leanne Higgins is not on trial here, Judge. The question is, did Matthew Higgins molest the child? All these things about coaching and all these motives that Mr. Lizo claims, that is very fair for cross-examination. It doesn't make sense to take up your time with a review with those things. It's not substantiated. And if we're going to go down this road, we're going to be evidentiary for every single thing. I have a man who's accused of this, who might be facing criminal charges, who refuses to take a polygraph. And the only thing we hear is that Leanne Higgins did this, Leanne Higgins did that. Leanne Higgins is not accused of molesting these children. That's all that's relevant right now, in my opinion, Your Honor.
Ms. Berger, do you see this as a concern as it relates to the children?
I do not, Judge. I've actually been able to speak with mother about kind of limiting talk about the case in the home with the children. That way we can, preserve the integrity of those things and to not further, traumatize them while we're in the process of going through court.
I've got attachment of this Tad Bailey, which documents that she has a child repeat this to him. So to the extent Your Honor needs an evidentiary here to determine that Ms. Higgins should not be talking to the children about these kind of things, I think we need to do that.
Your Honor, respectfully, Tad Bailey is not referenced in the discovery. Tad Bailey's cell number is not authenticated. This is going to be an absolute nightmare and a fishing expedition if we do an evidentiary hearing for every single hearsay allegation that Mr. Lizo is presenting to our court. So obviously you're the boss. We're going to have an evidentiary hearing. I'll bring it on, Judge, but I think it's a waste of time.
Well, first off, Your Honor.
Okay, Mr. Lizo, thank you. So here's what we're going to do. Ms. Berger has already addressed this. We have counselors in place for all of the children, and we will put that question to them to inquire into the children's mental health as it relates to this, to have a legitimate answer from someone who is having firsthand experience with the children, because it is not really my place necessarily to interfere with Ms. Higgins' right to discuss whatever she wants to discuss unless and until it brings a risk of harm into her children's lives. And I'm not, from where I'm sitting right now, I do not have substantiation that that is what is happening. So if there is an issue that comes to me from a counselor of one of the children, then we'll go from there on that. But until and unless I have some kind of actual documentation that this is harming the children, I'm not going to act on it or spend any time on my docket worrying about it. My priority is the children, and I will need some kind of indication that that is a risk to them. Anything else?
Not at this time.
All right, well, you've heard the rest of my directives as it relates to the progress of the case. I have reviewed the report, the additional documents, and have received that for purposes of pretrial review only. And I do find that the directives offered by Ms. Ariel Berger, as well as Ms. Renee Moore, who is consulted as an expert for purposes of determining visitation, that visitation will be directed to remain suspended, and contact directed from Mr. Higgins to the children should be done as prescribed in her letter through our caseworkers and then through the counselors for each of the children to determine whether or not, again, that is affecting their mental health.
I do have one I'm sorry, Your Honor. I thought of this as you were speaking. My client wants to get Christmas gifts for his children. We can have that taken to, through a third party. Is that an issue with the court?
I would leave that again to the discretion of the individual counselor for the children.
Okay.
Any contact from your client needs to be done only as sanctioned by the therapist for each of the children individually in order to preserve their mental health moving forward.
All right, so when he does get the Christmas gifts, we'll leave them unwrapped so they can look at them and they know.
They won't be getting them unless the therapist says it's okay.
Okay, that's fine.
Is what I'm saying.
Okay, thank you.
Last opportunity for any other issues.
Thank you.
All right, court's in recess. We'll see you then in January on this. Good luck.
Thank you, Judge.